Hello students, welcome to EPG Pathshala. I am Kiran Gupta from Faculty of Law, University of Delhi. Today we are going to discuss about a module Women and Law relating to matrimonial relief under paper Women and Law in subject Women Studies. The objective of today's study is to study various matrimonial remedies available to a woman under the personal laws, and also to highlight major modern changes in the ancient practices pertaining to divorce among various religious groups in India. Friend, marriage is seen as an institution of people coming together under the promise of spending a lifetime with each other. Every religion is under the firm faith that a marriage is a permanent union of men and women. However, with the view to provide relief to a spouse in distress, the law in almost all the countries of the world has provided for certain matrimonial remedies. The statutory law revolves around four basic arenas of matrimonial relief, and these are annulment of marriage if there is some defect in the validity of the marriage, restitution of conjugal right if the party has unreasonably withdrawn from the conjugal relation, judicial separation, and divorce. The term annulment of marriage refers to the process of declaring a marriage which suffers from a legal defect as null and void. The legal defects are of two categories, resulting in void or voidable marriage. A void marriage does not confer any status, right, or obligation upon the spouses. They won't become husband and wife, their children will not be legitimate, there is no mutual right of succession and even right of maintenance also. While a marriage can be declared as null and void through a judicial decree, even without such declaration, marriage is deemed to be void and the parties cannot claim any right against each other. A voidable marriage remains valid until it is declared as null and void through a judicial decree. Restitution of conjugal right refers to the right of one spouse to the companionship of other. Initially, only husbands could avail this remedy. This remedy was introduced into the Indian family law through judicial decisions. Later, it was incorporated into various statutes like the Civil Procedure Code, Specific Relief Act, and the other matrimonial laws. And both the husband and wife were awarded the right to enforce conjugality upon the other. A decree of judicial separation awarded the spouses claiming relief the right to live separately from each other while keeping the marital bond intact. This was more relevant for women as they could leave their husband's home and live separately and also claim maintenance from their husband since the marriage is still subsisting. The decree does not result in dissolution of the marriage and gives no right to the parties to remarry or to marry again. The decree of divorce dissolved the matrimonial tie and the spouses cease to be husband and wife. They are now free to marry again anybody. After divorce, the parties do not have the right to succeed to each other's property. There are certain ancillary reliefs also, such as alimony, maintenance, custody of children, division of property, which can be claimed along with any of the above mentioned matrimonial remedies. Nullity and annulment of marriage. Marriage confers the status of husband and wife upon a man and woman, thereby providing legitimacy to the sexual relationship and legitimacy to the children. As a consequence of this relationship, certain mutual rights and obligations accrue. The creation of these rights presupposes the capacity of the party to enter into a valid marriage. The concept of nullity is linked to the capacity of an individual to enter into a valid marriage. If the person lacks the capacity to enter into a valid marriage, the marriage is void or voidable. The capacities and the conditions for a valid marriage under the personal laws has already been discussed in the previous module. Restitution of conjugal rights. husband and wife have both a right and duty to the society, that is, comfort, consortium of each other. This is the unique feature of conjugal relationship. Husband and wife have a duty not to withdraw from the society of the other without a reasonable reason. If one of them withdraws from the society of other, the aggrieved spouse has a legal right to claim a decree of restitution of conjugal rights against the other spouse. However, the spouse who has forsaken his or her spouse cannot ask for the relief of restitution of conjugal rights. This is the only positive relief aiming at affirming and preserving the marriage. The remedy of restitution of conjugal rights is available to members of all communities in India under the various statutes like Section 9 of the Hindu Marriage Act 1955, Section 32 and 33 of Divorce Act 1869, Section 36 of Parsee Marriage and Divorce Act 1936, Section 22 of Special Marriage Act 1954. Before the enactment of these statutes, this remedy was granted to Hindus as well as Muslims by the judiciary under the general civil law of the land and by the judicial decisions. Though initially only husbands availed of this remedy, later it was also used by deserted wives to restore their marriages. Section 9 of the Hindu Marriage Act laid down 4 conditions for decreeing the grant of this relief. Firstly, the respondent has withdrawn from the society of the petitioner. Secondly, the withdrawal by the respondent is without a reasonable cause. Thirdly, the court is satisfied that the statements made in the petition are true. And fourthly, there is no legal ground for refusing to grant the application. Withdrawal from society may take place even when the parties are living under the same roof. Withdrawal means withdrawal from a state of affair, that is conjugality, and not from a place. When the husband himself is instrumental in driving the wife out of her matrimonial home, it cannot be said that the wife has withdrawn from the society of her husband. The defense available to the remedy of restitution is the presence of reasonable excuse for withdrawal. If the cause or excuse for withdrawal is reasonable, court will not award a decree of restitution to the petitioner. Though technically both husband and wife are able to use this remedy, studies reveal that far more husbands than wives file for this remedy. When a wife files for maintenance, as a retaliatory measure, husband file a petition for restitution. Very often, this remedy is used as a legal ploy to defeat the wife's claim rather than as a genuine intention of reconciliation. Section 13(1)(a) of Hindu Marriage Act made non-restoration of conjugal relations for 1 year or more after the decree of restitution a ground for divorce available to both the parties. Husbands are now using this restitution decree as a stepping stone to get a decree of divorce. This resulted in challenging the constitutional validity of Section 9. The Supreme Court in Saroj Rani versus Sudarshan Kumar, deciding in 1984, upheld the constitutional validity of this provision on the ground that it is a benevolent provision which would facilitate reconciliation and save the marriage. When the husband himself obstructs the execution of the decree of restitution of conjugal right, the wife was granted a decree for divorce. In Prabhat Kumar Chakravarti versus Papia Chakravarti, the Calcutta High Court held that when the husband himself prevented the wife to comply with a decree or restitution, the wife is entitled to a decree of divorce. The question is, does the wife's refusal to give up her job or avocation at the instance of the husband constitutes withdrawal from the society of the husband, that too without a reasonable cause? The views of Punjab and Haryana, Andhra Pradesh and Madhya Pradesh High Courts is that a wife cannot choose any job contrary to the wishes of her husband. If she is already in job, she must abandon it whenever the husband asks her to do so and must go to live with him at the place of his liking. However, Punjab and Haryana High Court in Kailashwati versus Ayodhya Prakash in 1977 makes it clear that this right of the husband is subject to two qualifications. Firstly, the husband must actually establish a matrimonial home wherein he can maintain his wife in dignified comfort in accordance with the means and standards of living of the parties. Secondly, it must be crystal clear that the husband, while claiming the society of his wife in the matrimonial home, should be acting in good faith and not merely to spite his wife. The views of some other high courts is different on this point, and they have taken a view that a wife gainfully employed at a place away from the husband's home who has no intention of breaking off from him and was willing to visit him occasionally could not be compelled to give her job by means of a decree of restitution of conjugal rights. In Swaraj Garg versus K.M. Garg, the Delhi High Court in 1978 held that a husband cannot force the wife to leave a government job while claiming a decree of restitution. The court is of the opinion that working wives who are better situated than their husbands have the right to choose the place of the matrimonial home. In Suman Kapoor versus Sudhir Kapoor, decided by the Supreme Court in 2009, the Supreme Court cited women's focus on their career as neglect of their household responsibilities. The objections are being raised in certain groups that Section 9 of the Hindu Marriage Act serve no useful purpose in today's society as it has more been misused than used. The section serves the social purpose as an aid to the prevention of breakup of marriage. The courts can prevent the misuse of this remedy by carefully examining the genuineness of the petition filed by the husband. There are significant safeguards in Section 9 itself to prevent it from being a tyranny. Judicial separation. The decree of judicial separation entitles a spouse to sever conjugal relations with the other without breaking the matrimonial tie. For women who are subjected to cruelty, the right to judicial separation became an important remedy to obtain the right of separate residence, maintenance, and custody of children. This remedy is viewed as an intermediate measure for spouses who are facing matrimonial conflict but were not yet ready for divorce. All personal law statutes contain this remedy. Section 13(1)(a) of the Hindu Marriage Act provides non-restoration of conjugal relations for 1 year or more after a decree of judicial separation as a ground for divorce available to both the parties merely on the ground that they have not been able to resume cohabitation. The Hindu Marriage Act 1955. In this act, the ground for claiming decree for judicial separation was specified in Section 10, which were different from the grounds prescribed for divorce under Section 13 of the Act. By the Matrimonial Laws Amendment Act of 1976, the grounds specified in Section 10 were merged with the grounds of divorce under Section 13. Now, the parties are free to claim either judicial separation or divorce on the same ground. Section 13(a) of the Act, which deals with alternate relief in divorce proceedings, permits the court to grant a decree of judicial separation where a petition is filed for decree of divorce if the court thinks it fit. In India, in all uncodified personal laws except Muslim law, the marital bond was treated as eternal and unbreakable. Hindu law, Christian law, even Parsee law did not provide for dissolution of marriage. It is only under the Muslim law that a marriage is treated as a dissoluble union. With the passage of time, it was realized that sometimes it is very difficult to remain adhered to matrimony. This resulted in the enactment of various statutory personal laws permitting dissolution of marriage by a decree of competent court. Under modern times, the concept of divorce can be categorized under mainly three categories. fault theory of divorce. The basic ingredient of a fault theory of divorce are: there must exist a guilty party or a party who is responsible for having committed one of the specified matrimonial offence. There must also exist an innocent party who has suffered due to the misconduct of the guilty party, and the innocent party should have no role in the cause of the conduct, that is, there must be no collusion between the guilty party and the innocent party. Mutual consent theory. Marriages very often fail not because of the fault or guilt of one of the spouses, but because the spouses are not compatible in their temperament. Despite their best efforts, they are unable to live together as husband and wife. To remedy the problem faced by such couples, the notion of consent divorce came to be included in the matrimonial laws. The purpose was to enable couples to adopt honest means to achieve legitimate ends. Irritable breakdown theory. This theory is based on the fact that irrespective of fault of either or both parties, a marriage can be terminated if it is shown that nothing survives in the relationship. Borrowing the phrase used by some judges, a marriage which is reduced to dead wood can be dissolved. The basic premise of this theory is that if a marriage has broken down without any possibility of repair, or we can say irretrievably, it should be dissolved without ascertaining the fault of either party. Under the Shastric Hindu law, the marital bond was eternal and unbreakable. Divorce was not provided, however painful cohabitation may be. In some non-Dvija communities, the custom of divorce started, and the courts enforced these custom of divorce provided for dissolution of marriage without the intervention of the courts. The Hindu Marriage Act 1955 has introduced a revolutionary change by permitting divorce to all the Hindus on certain reasonable grounds, and Section 13 of the Hindu Marriage Act specified those grounds and the conditions necessary for dissolution of marriage on those grounds. This permission was given for the first time in the history of Hindu law by this act. The act saved all the customs and special legislation granting the dissolution of marriage before its commencement, and this was provided under Section 29, subsection 2. The original provision of the Hindu Marriage Act 1955 regarding divorce have been liberalized by the Marriage Laws Amendment Act of 1976. The relief of divorce may be obtained in respect of any Hindu marriage, whether solemnized before or after the commencement of the Act of 1955. A divorce petition has to be made to a court either by the husband or by the wife, that means by the parties to the marriage. The third person, including parents or children, cannot make a petition for divorce. The Act permits judicial divorce under Section 13 of the Hindu Marriage Act. Section 13 has various parts, namely 13(1) having clauses 1 to 7, 13(b) having clauses 1 to 4, 13(1)(a) having 2 clauses, and Section 13(b) and 13(a). The grounds for divorce as provided under Section 13 are divided into two types: the common or general grounds, which are based on guilt, fault, disability, etc., on which both parties to a marriage, husband or the wife, can obtain divorce. They are 11 and are given in subsection 1 and subsection 1a. The other grounds are the grounds which are available to a wife exclusively in addition to the general grounds. They are 4 and are mentioned in subsection 2 of section 13. There is, however, no exclusive grounds for divorce for the husband. Section 13 of the Hindu Marriage Act states the grounds and reasons for divorce, which are as follows: the extramarital sexual relation after marriage, cruelty, desertion, conversion, incurable unsoundness of mind or mental disorder, virulent and incurable leprosy, venereal disease in communicable form, renunciation of the world by embracing a religious order, absence for a continuous period of 7 years, no resumption of cohabitation for 1 year after decree of judicial separation or restitution of conjugal rights. The grounds which are available only to wife are: 1. If the husband has more than one wife married to him before the commencement of the Hindu Marriage Act, then either of them or any one of them can claim divorce from him. Second, if the husband has indulged in unnatural sexual relation like rape, bestiality, and sodomy, then wife can claim divorce. Third, if there is no resumption of cohabitation for 1 year between the parties after the passing of the decree of maintenance in favor of the wife by the court, then wife can claim divorce. Fourth, who a girl is married before she attained the age of 15 years and she renounces the marriage before she attained 18 years of age can get a decree of divorce irrespective of the fact whether the marriage is consummated or not. Divorce by mutual consent is addressed under Section 13B of the Act, which was added in 1976. The petition for obtaining a decree by mutual consent has to be presented jointly by the husband and the wife. Another distinctive feature of the 1955 Act is that it ensures that precautions be taken by court before passing a decree. The court is directed to satisfy itself that the one who comes to equity must come with clean hands and there exists no bar to granting the relief claimed. The Act also entrusts court to attempt reconciliation. The duty to effect reconciliation is mandatory. Irritable breakdown of marriage is yet not a ground of divorce provided under the Hindu Marriage Act, despite the recommendations of the Law Commission in its 71st and 217 report to introduce irritable breakdown of marriage as a ground for divorce. In a number of judicial decisions, the Supreme Court has also suggested to make this as a ground for divorce. Islam also insists on the subsistence of a marriage and prescribes that breach of marriage contract should be avoided. Prophet Muhammad declared that among the things which have been permitted by law, divorce is the most detestable. Divorce being an evil, it must be avoided as far as possible. But in some occasions, this evil becomes a necessity because when it is impossible for the parties to the marriage to carry on their union with mutual affection and love, then it is better to allow them to get separated than compel them to live together in an atmosphere of hatred and disaffection. The basis of divorce in Islamic law is the inability of the spouses to live together rather than any specific cause or guilt of a party on account of which the parties cannot live together. A divorce may be either by the act of the husband or by the act of the wife or by their mutual consent. A decree of divorce from the court is not required under Muslim law. The basis for this extrajudicial divorce is irretrievable breakdown of marriage or the mutual consent of the parties. A Muslim husband can dissolve the marriage by making a unilateral declaration of pronouncement of divorce to the wife according to the various forms recognized by the law. This is called talaq. The express talaq by husband has to be clear and in unequivocal words, such as I have divorced you are utter. The express talaq falls into two categories: talaq ul sunnah, which has two forms, a hasan, most approved, and hasan, less approved. And the second category of talaq is talaq biddat. This form of talaq is not recognized by Shias. Talaq biddat is basically three talaqs pronounced at the same time. It is irrevocable immediately. Talaq biddat results in immediate irrevocable dissolution of marriage. In this talaq, three pronouncements are made in one go. that is triple talaq, 3 times, either in one sentence or in 3 sentences, signifying a clear intention to divorce a wife. In Shamim Ara versus State of Uttar Pradesh, the Supreme Court in 2002 held that the correct law of talaq as ordained by Holy Quran is that talaq must be for a reasonable cause and be preceded by attempts at reconciliation between husband and wife by two arbiters, one from the wife's family and the other from the husband's. If the attempts fail, the talaq may be effected by clear pronouncement of talaq. In Masroor Ahmad versus State of National Capital Territory of Delhi, the Delhi High Court held that a triple talaq, even for Sunni Muslims, be regarded as one revocable talaq. This would enable the husband to have time to think and to have ample opportunity to revoke the same during the iddat period. Even if the iddat period expires and the talaq can no longer be revoked, the estranged couple still has an opportunity to re-enter matrimony by contracting a fresh nikah on fresh terms of mahar. Recently, in Saira Bano versus Union of India, Supreme Court declares triple talaq as not a part of Shariat and is arbitrary, therefore not protected under Article 25 to 28 of the Constitution. The court specifically declared the practice of triple talaq as unconstitutional. Besides talaq, a Muslim husband can repudiate his marriage by two other modes, that are ila and zihar. They are called constructive divorce. Muslim law also recognizes divorce by mutual consent, which is called mubarak. Mubarak is where both the wife and husband decide mutually to put an end to their marital tie. Muslim law also allows divorce by wife. Talaq-e-tafweed or delegated divorce is recognized among both the Shias and the Sunnis. The Muslim husband is free to delegate his power of pronouncing divorce to his wife or any other person. He may delegate the power absolutely or conditionally, temporarily, or permanently. The power of talaq may be delegated to his wife also. In li'an, if the husband levels false charges of unchastity or adultery against his wife, then this amounts to character assassination, and the wife has got the right to ask for divorce on these grounds. A Muslim wife can claim khula from the husband. Khula is the mode of dissolution when the wife does not want to continue with the marital tie. She proposes to her husband for dissolution of marriage, which is generally accompanied by her offer to give something in return. Khula is a divorce which proceeds from wife, which the husband cannot refuse, subject only to reasonable negotiations. The Dissolution of Muslim Marriages Act 1939 enables a Muslim women of all sects to seek dissolution of marriage by a decree of court on any one or more of the following grounds, namely, that the whereabouts of the husband have not been known for a period of 4 years, that the husband has neglected or has failed to provide for her maintenance for a period of 2 years, that the husband has been sentenced to imprisonment for a period of 7 years or upward, that the husband has failed to perform without reasonable cause his marital obligations for a period of 3 years, that the husband was impotent at the time of marriage and continues to be so, that the husband has been insane for a period of 2 years or is suffering from leprosy or virulent venereal disease, that she, having been given in marriage by father or other guardian before she attained the age of 15 years, repudiated the marriage before attaining the age of 18 years, provided that the marriage has not been consummated, that the husband treats her with cruelty. In Itwari versus Ashgari, the court observed that Indian law does not recognize various types of cruelty, such as Muslim cruelty, Hindu cruelty, and so on, and that the test of cruelty is based on universal and humanitarian standard, that is to say, conduct of the husband which would cause such bodily or mental pain as to endanger the wife's safety or health. The court in this case decided that if the husband married again during the subsistence of the first marriage, it will amount to cruelty to the first wife, as her status in the society will be diminished because of her husband's second marriage. Marriage, as per Christianity, is union of men and women for life. As such, there was no concept of divorce in Christian law. The Divorce Act of 1869 for the first time granted the right for dissolution of marriage to a Christian couple. The Act of 1869 in section 10 specified the grounds for divorce, which are different for husband and wife. While for the husband, adultery by the wife is a ground for divorce, simple adultery by the husband is not a ground for divorce for wife. The Act of 1869 was drastically amended in 2010 on the demand of the Christian community itself, by which under section 10(1) 10 grounds were specified, which are available now to both husband and wife. The grounds are almost similar to those under the Hindu Marriage Act. Prior to this 2010 amendment, the grounds for divorce for husbands were quite lenient, while for wife to claim divorce, the ground to be proved is not just one but a mixture of number of grounds. The wife has been permitted to sue for divorce on additional ground if the husband is guilty of rape, sodomy or bestiality. Section 10, subsection 2 of the Act. Section 10A of the Act of 1869 made a provision for dissolution of marriage by mutual consent of the parties, which is similar to Section 13B of the Hindu Marriage Act. This ground was added by the 2010 amendment to the Act. The Parsee's Marriage and Divorce Act 1936 governs divorce proceeding for Parsees in India. As per this Act, if consummation of marriage is impossible because of natural causes, such marriage can be declared null and void at the instance of either party. This is provided in section 30 of the Act. A suit for divorce, however, may be filed on the grounds mentioned in section 32 of the Act. The parties can remarry if no appeal is subsisting against the decree of divorce, or time to file such appeal has elapsed, or prior marriage has been terminated by death. The Act of 1936 also provides divorce by mutual consent, section 32B of the Act, which was added in by the 1988 amendment to the Act. However, the divorce by mutual consent under the Act is different from the divorce claim under the Special Marriage Act or the Hindu Marriage Act. The court under the Act of 1936, which is applicable to Parsees, starts proceedings immediately after receiving the application, while in the other two acts of 1954 and 55, there is a 6 months waiting period. Jewish law of divorce. The Jewish law recognizes divorce on the petition of the husband and wife separately on certain grounds. The Jewish law also recognizes divorce enforced by court without even having any petition by either party. Divorce under the Special Marriage Act 1954. As we know, friends, along with the personal laws which are applicable to different persons belonging to different religious communities, we have a civil law which is available to all irrespective of their religion. This is the Special Marriage Act of 1954, which lays down a civil ceremony for the marriage. The marriage under the Act is essentially a civil contract. The Marriage Laws Amendment Act 1976 has amended the grounds for divorce under the Hindu Marriage Act and this Act also, and has brought them at par with each other. However, conversion of spouse is not a ground for divorce under the 1954 Act. Also, two specific grounds have been provided for the wife alone in the 1954 Act, that is provided by section 27(1)(a) of the Act. Section 27B provides for divorce by mutual consent, which is similar as Section 13B of the Hindu Marriage Act. The issue of family law reform does not need to be approached as a policy that is against the religious sensibility of individuals, but simply as one promoting harmony between religions and constitutionalism. No citizen should be left disadvantaged on account of their religion. There is a need to enact a uniform law of divorce applicable to all irrespective of religion so as to remove discrimination against women. Irretrievable breakdown of marriage should be made as a ground for divorce available to all irrespective of the religion. Thank you.